All rise. First District Court of Appeal is now in session. All who have business before this court draw near, give attention, and shall be heard. May God save these United States, the great state of Florida, and this honorable court.
Thank you. You may be seated. Welcome to the First District Court of Appeal. We have one case on our argument docket this afternoon. David Edward Johnson versus State of Florida, case number 22-2298. Appellant's counsel. And if you'd like to reserve rebuttal time, let us know.
Please reserve 4 minutes of my time for rebuttal.
How many?
4 minutes, please.
4 minutes. Thank you.
May it please the court, my name is William Pinnell, and I represent David Johnson, the appellant in this case. In this case, trial counsel's performance was grossly deficient. It resulted in the introduction of uncharged collateral crimes, inadmissible hearsay that bolstered the credibility of the alleged victim, and the state being permitted to comment on Mr. Johnson exercising his right to remain silent. This case should have been a credibility contest between Mr. Johnson and the alleged victim had counsel performed in a reasonable fashion. Under these circumstances, it's impossible for this court to have confidence in the outcome of the trial in this case, and we ask the court to reverse for a new trial where Mr. Johnson is given competent counsel to represent him. I'm going to start with what I believe is the most egregious error of the trial attorney. During her cross-examination of the detective, she opened the door to testimony about Mr. Johnson exercising his right to remain silent. The case law is clear, including the Smithy case from the 5th DCA, that you can be ineffective for opening the door to prejudicial testimony. And the trial court in this case found that trial counsel was deficient for doing so in this case. It's our position that the trial court erroneously concluded that there was no prejudice to Mr. Johnson as a result of the comment on his silence. And
Is your argument that that's per se prejudice?
I don't think it's per se prejudice. I think that in this case, as the court's aware, this court has addressed this situation in 2 different cases, in the Williams case and in the Floyd case. And I'd suggest that this case is far closer to Floyd. In Williams, you had the testimony of 3 separate victims, a tacit admission from the defendant, and some other very incriminating circumstances. Here, this was mostly a he said, she said argument. And as the court is aware, all the appellate courts in Florida have said that the comment on the right to, on a person exercising his right to remain silent is a serious error that creates an inference that the defendant is guilty in the minds of the jury. The court relied on the fact that it found, the trial court said that there was overwhelming evidence. I respectfully disagree. It also said it wasn't made a feature of the case because it wasn't mentioned in closing. And I suggest in some cases that might be true, but in this case, this was a very short trial. It was less than 2 days. Once you take out the jury selection, it's only 180 pages of opening statement, testimony, and closing arguments. There's 6 witnesses. So I don't think it can be considered a blip on the map. This was something that was pretty obvious to the jury and was highlighted because it was such a short trial. Additionally, trial counsel asked 4 separate questions to point out that the police did not speak to Mr. Johnson. So then there was a 4-page bench conference, and after the bench conference, the state was able to do a redirect and point out that Mr. Johnson invoked his right to remain silent. So certainly it was highlighted for the jury. The jury heard it right after this giant bench conference. So I don't think it's any way to say it's isolated. And again, we say that the evidence is nowhere near as strong as it was in the Williams case, where there was 2 victims, a collateral victim. The defendant sent a letter to the mother of the appellant's child asking her to apologize and asking them to change their stories. Here we have a situation much closer to Floyd, where the defense lawyer or the state crossed the defendant on speaking to the police, and they said because credibility was a central issue, that there was a reasonable probability that the outcome would have been different. There's no indication in the Floyd case that the comment on the right to remain silent was referenced in closing, so I don't think that's a requirement, again, where we have a short trial and it's highlighted by this bench conference. And as the court is aware, a reasonable probability for prejudice is not by preponderance, it's just, does it give you pause or lack of confidence in the verdict? So we don't have to prove beyond 51% that there would have been a different verdict. We just have to prove that there's a question here, whether the outcome would have been different. And I think there's a legitimate question under this court's Floyd case. And that alone, I think, is sufficient. But then we have all these other errors of trial counsel that I think cumulatively easily establish prejudice on Mr. Johnson's behalf.
Let me ask you, you're a lawyer with experience in criminal cases. Looking at the dynamite charge that we sometimes see used in the trial court, can you tell me, in your view, what is the most significant evidence against your client at trial? In other words, I know that's putting you in a tight spot as an advocate, but assuming we share some of your concerns for the sake of a hypothetical, what I've seen is that the collateral crime evidence that you also attack in another issue is fairly significant. So just talk to us a little bit, if you don't mind, about the big picture here. What was your client facing in terms of inculpatory evidence?
Well, obviously, there was the
victim's testimony.
Direct testimony of the alleged victim is pretty damaging, and it's always difficult to hear a minor child testify and give the testimony she did in this case. The CPT interview was also harmful because it restated and corroborated her testimony and corroborated her credibility, but also introduced prior bad acts that were uncharged.
And one of them was something that had happened that night, the night before?
There was something
An
shortly
exposure?
before and shortly after the incident in question, yes.
And the jury heard that he allegedly exposed himself, is that it?
Correct, multiple times, yes. Multiple times. The jury heard from the CPT interview and from some other witnesses that he had exposed himself on multiple occasions. And then through another witness, there was testimony that there was, quote, escalating conduct, and that there had been conduct before the date in question.
Yes, and the lawyer followed up on that, which didn't seem to be helpful to your client.
Correct.
So,
I also think obviously the contradictory testimony between what Mr. Johnson said and then his wife testified to was not helpful.
that was obviously not helpful.
Sure.
So, the jury heard the testimony of the victim. Your argument is, if they had not heard this inconsistent statement about whether it was an accident, if they had not heard the similar fact evidence, if you will, and that's the reasonable doubt or the reasonable question mark in terms of the reliability of the trial.
Sure, because then now we just really have Mr. Johnson's testimony, which was unwavering, that he didn't touch her at all inappropriately, and then against her testimony, without any of this improper hearsay corroborating her credibility, or any of the comment on the silence, or any of the prior bad acts putting Mr. Johnson in a bad light.
Well, let's talk about the prior bad acts for a second. So, in your brief, you address the argument that the trial court really was not in a position to determine that, well, even had these arguments been raised at trial, they would have not been successful. Address that, if you will.
Sure. Well, so the trial judge said, well, he acknowledged that there was no 404 notice and no 90.803 notice, but essentially concluded that the testimony would have been admissible had there been a pretrial hearing on those issues based on what he heard at trial. And I mean, it's kind of circular and kind of blows up the rule if the judge can just make that conclusion after hearing the trial testimony. The case law is pretty clear that you need notice, and for the child hearsay, you have to make certain findings of fact. And in a hearing out of the presence of the jury, and then for the 9404, you have to prove by clear and convincing evidence that the acts occurred and that the prejudicial value doesn't over.
And he found the similar fact evidence was inextricably intertwined,
He
correct?
did, and I believe the court was incorrect with that.
Why is that?
The case law is clear that that testimony is only admissible when it's necessary to explain the entire context or the story of the charged offenses couldn't be told without it. And the alleged victim in this case had no problem telling the story during her testimony without reference to these other acts. They simply didn't need that testimony, and the only purpose for its introduction was to prejudice Mr. Johnson in the eyes of the jury.
And one of the witnesses talked in terms of escalating behavior that began before that day even?
Yes, she did, and that was, and then it was highlighted by trial counsel, who then asked her again about the escalating conduct, and that witness then said there was sexually charged conduct prior to the date of the incident in this case. So, I mean, the case law is clear that prior collateral conduct is presumptively prejudicial, and I think it's even clearer in a context where we're talking about sexual abuse of a minor that that's going to prejudice the defendant in the eyes of the
Now,
minor.
you talked in
in
your
the eyes of
brief-
the jury. Sorry, go ahead.
You addressed in your brief this point that the lawyer had some ethical difficulties with the Florida bar, and that the lawyer told your client that she had experience or she was confident in terms of doing this. Now, she had won an acquittal in a similar case, apparently.
I think she said that she'd won an acquittal where she got it by the prosecutor. This kind of opened the door to the comment on the silence, but I think she testified this was the first sexual battery case or sexual molestation case she'd ever taken to trial. So she had some success, and I guess tricking a prosecutor and getting by him.
But what kind of case was that?
I don't know.
You don't
I
know.
don't think that's in the record. I'll reserve the rest of my time for rebuttal if the court doesn't have any questions.
Thank you.
May it please the court, Heather Ross for the state of Florida. Today, we need to focus on the big picture here. In light of all the circumstances, did the defendant receive a fair trial? The Strickland benchmark for judging a claim for ineffective assistance is whether trial counsel's conduct was so undermined that undermined the proper function of the adversarial process that the trial could not rely on as being produced a just result. Here, when it comes to Strickland, I sometimes think we forget while we're checking off boxes, making sure that there's sufficient performance and there's prejudice presented. The purpose of the Sixth Amendment is not to prove or to improve the quality of legal representation, although that is a goal that we all need to strive for. The purpose is to ensure that criminal defendants receive a fair trial. Here, the defendant did receive a fair trial. Trial counsel, while she was not Johnny Cochran, she was able to depose witnesses and test the state's case. She cross-examined witnesses. She put on her own series of events that she said that the victim, her statements are inconsistent, and I'm going to show that. So she stipulated for the CPT video to come in. If she said, I needed those inconsistent statements to come in so I could chip away at the credibility of this victim. Now, and I think she accomplished that. She, in her closing, pointed out that the inconsistencies with the victim's statement in the CPT video compared to what her trial testimony was. Also, when you were looking at the ground that defense counsel says is the most prejudicial to the defense is the the comment on the right to remain silent. While, yes, it is a serious charge or a serious error to make, I don't think it goes to whether the state proved its case. It does not provide anything for that. As for the similar fact evidence that came in, again, defense counsel wanted that evidence to come in so that she could chip away at the victim's credibility.
How did that chip away at the credibility of the victim?
Well, she wanted that evidence to come in, and then it came in through the CPT interviewer, and then the victim testified. The victim left out specific pieces of that testimony from the CPT video. So she didn't talk about looking at the Playboy magazine. She didn't talk about, what were the other things? She didn't talk about some of the baby talk that he was talking to her during the molestation. She simply did not. This was her trial strategy from the get-go, from opening to closing. It was exactly what she wanted to do and thought it was the best defense for her client.
But the interview brought in the similar fact evidence?
Excuse me?
The interview brought in the similar fact evidence?
The interview did. She did not redact those pieces of the similar fact evidence because from her point of view, it was just it was basically the whole criminal episode of that evening. In a lot of the cases that defense counsel cites, the discrepancy is that a lot of these cases, the prior crimes or the collateral crimes or similar fact evidence come from years, weeks, months, years, compared to this. All of it happened on one night. And as to the comment.
Well, you had the one witness that said that this was escalating even before that night, correct?
Yes, sir. She did, and she fully admits that she shouldn't have asked a question that she didn't know the answer to. But once she saw that, once she asked that question, she answered and she asked one more question, she quickly changed her line. And I think that would fall into any trial counsel's repertoire of a defendant said something or a witness said something that they aren't expecting, that they quickly change their line. It never came out that the details of the prior incidents or timeline or anything like that.
Well, talk, if you will, about the testimony about whether it was accidental and the statement that was brought in from the defendant that he claimed it was an accident. Yes.
Well, the statement that came in through the victim's mother. Defense counsel said, I asked the defendant something, or the victim's mother, something that I had not asked her in depositions, and that she acknowledged that that was probably not a good idea to do, but it came in, and at that point, she was a little taken aback, but her trial prep with the defendant and the defendant's wife was consistent. They always went.
And then what did the wife testify to?
Excuse me?
Did the wife testify?
Yes, the grandmother/wife testified. That was the last witness for the defense.
And what did the defendant's wife/grandmother say about the idea of accident versus it didn't occur?
She testified that the defendant had told her that, yes, it happened, but it was an accident.
I mean, isn't that, I know you're in a difficult position. It's hard for the state to represent the defense attorney in an ineffective assistance claim. It's kind of the nature of the beast, and it's not instinctual, if you will. It's difficult. But don't you think that's, all in all, these errors are pretty devastating? I mean, in a short trial, the jury hears, well, he said it was an accident, and he has to testify, no, I never said that. The jury hears that, well, in fact, he didn't just molest her, he exposed himself to her several times. The jury hears, well, he had a chance to tell the police he didn't do it, and he invoked his right to remain silent. I mean, in a short trial, that's quite a combination of errors, is it not?
In this circumstance, some of the errors were bad. I can't defend
I understand,
her errors,
and I'm not
everything,
asking you to do
but,
that. But you talked, and I appreciate the focus on Strickland, and I appreciated in the brief how you had long excerpts from the trial court's order. That was helpful. But in the big picture, as you put it, do you think there's reason to doubt the reliability of this trial and her representation?
No, sir.
And why is that?
The reason is because I guess the three grounds, the CPT video, the similar fact evidence, and maybe the.
But why would you want the CPT, why would you not try and keep that CPT video out at all costs? Now, it may not have been successful, and that's an interesting analysis here. But why wouldn't you fight to keep the CPT interview out? I guess you could call it a reasonable strategy to try and show how the police never talked to him, except they did. and then the accident versus it never happened testimony. Why would you ask the victim's mother, or was it grandmother?
She
The
asked the
victim's
victim's mother.
What the defendant said?
Oh, well, she asked she asked the mother what the grandmother / wife had said the defendant had told her. So it's,
Why would you ask that?
to speculate, I have no idea. Like,
And
it would
that's-
be
and
pure
that's-
speculation if I tried
Right,
to.
and that's my concern here, is that I don't really see a reasonable explanation for that tactic.
And by looking at everything and
You
revisiting.
don't want to talk about what your client said, right? You don't want to do that.
Looking at everything, you have to look at what her defense strategy was. This was he said, she said. She was going to have to figure out how to convince them that the victim was not credible. It was going to be a credibility determination between the two. And in her experience, again, she's not Johnny Cochran. She had limited experience. She felt that this was the best strategy to get an acquittal for her client.
And was this her first sexual crime trial?
Yes.
Is that in the record?
Yes, sir, it is. But again, looking at the bigger picture, the CPT video, the similar crime evidence that came in, all of those were part of her strategy. Those are the only two
Now, it can't be a reasonable strategy to get in similar fact evidence. I mean,
that was her.
that's totally devastating in a criminal trial.
Unfortunately, that is what I have here, and
I
that is
understand.
what we have here. But
And that's different than what the trial court found, right? The trial court said that was an unreasonable way to go about it.
correct, that it was not reasonable, but that it was her trial strategy. And even if something's unreasonable, it's not necessarily detrimental. Those are the only two grounds that go to whether whether the state proved its case or not. The mentioning of what the grandmother said to the mom, and the right to remain silent issue, those don't go to the weight of the state's evidence, or go to the evidence that the state had to present in this case. And if there's no other questions, I would ask this court to affirm the denial of the post-conviction motion. Thank you.
Thank you. I'm going to ask you what I kind of left hanging with your opposing counsel, and that is, let's assume the lawyer did what it seems to me at least she should have done, and that is done an 803 motion, tested the reliability of the out-of-court statements, obviously not asked questions she didn't know the answer for. That's kind of trial strategy 101. And just assume worst case scenario, why is the reliability of the trial in question? What damaged the credibility of the victim had this not come in? You're thinking that a jury that just hears a young woman say, he molested me and this is how it happened, and he says, well, no, I never did that. Isn't that basically what we're talking about here?
It would have been had trial counsel performed reasonably. I think this case is a straight he said, she said, without the errors of trial counsel. And then we have the jury would make a credibility determination based solely on the alleged victim's live testimony and the live testimony of Mr. Johnson. And by all accounts, including trial counsel's accounts, Mr. Johnson came across well. Even the trial judge at the end of the evidentiary hearing suggested that the tipping the scales didn't occur until later in the trial when the wife testified. So I think when you read his testimony, he's not.
The wife testified that he told me it was an accident.
Correct.
It was
our
accidental
position
touching.
that trial.
Oh, and why did she call the wife again?
I don't know the answer to that. That's to me. Once that comes out, and she says it's a surprise that it comes out from the daughter, and she testifies she does not check with the wife to see what she's going to testify to on that fact. And to me, that's ineffective assistance. You can't put her up there blindly and hope she doesn't confirm that. If she's going to confirm that statement, you need not to call her as a witness when you already put the defendant up there and say it didn't happen. And the trial judge himself, who was the judge at the trial and at the post-conviction hearing, said that was the turning point of the case. So he thought it was a closed case until that happened. And all the errors, we had a credibility contest, but every single error pushed the scales in favor of the alleged victim on credibility.
I understand that, but my question is, do we look at whether or not an 803 motion and a 404 motion would have been successful? And if, like the trial court, we determine, well, those motions would not have been successful, then it's sort of a no harm, no foul situation, right?
So I disagree with that analysis. I think that they didn't give the notice. So I think the objection at trial would have been sustained under the case law, that, there was no notice, there was no findings. The state didn't follow the rules to get that evidence in. So I think the prejudice analysis isn't would have that been granted. The prejudice analysis is how did that affect the credibility of the alleged victim. There's no dispute in this case that the notices weren't filed. I don't know how the state gets around that in this case.
So, as a matter of law, your argument is, in a criminal case not involving ineffective assistance, where the state does not file the 803 notice, we'll start with that one, then the trial court cannot allow that evidence in. Is that correct?
There's limited cases where they allow that in, where they say that the notice was a couple days late and the defense counsel was still on notice. But the general rule is if there's not notice, that it doesn't come in. But again,
what about the argument by your opposing counsel that the strategy of the bringing in the CPT interview was to show inconsistencies between her testimony and her prior out-of-court statements?
So I would ask the court to look at the cross-examination of the alleged victim and the closing, and I think you're going to find an absence of evidence of the defense lawyer pointing out inconsistencies. I think the closing argument is 2.5 pages by the defense, and I don't believe there's any inconsistencies pointed out there. So The strategy was unreasonable, and Mr. Johnson was prejudiced, and we'd ask that the court reverse for a new fair trial. Thank you.
Counsel. All right, that concludes our sitting for this afternoon. We'll be in recess.
All rise.